Chief Justice of Pakistan की under his umbrella और Chief Justice Lahore High Court, Justice Jawad Hassan और Justice Shahid Kareem, Honorable Judges of the Lahore High Court and Honorable Chief Justice, they have been most instrumental in putting together and seeing that the commercial court ordinance is promulgated, it is set in place, commercial courts are established, judges are assigned, and this project is on the way. थोड़ा सा मैं बैकग्राउंड में ये डिस्कस करना चाहूँगी कि कमर्शियल कोर्ट्स को इस्टेब्लिश करने की ज़रूरत क्यों पड़ी और व्हाट इज़ द नीड कि हमें कमर्शियल कोर्ट्स को ख़ास तौर पे इतनी इम्पोर्टेंस देनी चाहिए, देने की ज़रूरत पड़ी है. इसमें वाई वी कन्फ्लेटेड कॉमर्स टू द सेम इम्पोर्टेंस एज वाई नॉट अदर केसेस जो कि हम उनको भी इसी तरह जैसे चलते रहें वैसे क्यों ना चलाएं. तो ऑब्वियसली विद द ग्रोथ ऑफ बिजनेस, द ग्रोथ ऑफ कॉमर्स, द इम्पोर्टेंस ऑफ कॉमर्स, द इम्पोर्टेंस ऑफ द इकोनॉमी, द इम्पोर्टेंस ऑफ ईज ऑफ डूइंग बिजनेस एज promoted by the ADB project that is carrying on over here, and there is an obvious need कि जब तक आपका judicial climate और आपका legislative framework, आपका judicial framework support नहीं करता to the business and the economy and the ease of doing business, and also the surety of having consistent judgments and the surety of having the surety that cases will be decided fairly, justly, in accordance with law, expeditiously, transparently, free of interference and free of corruption. I think these are the parameters that every investor looks at, चाहे वो domestic investor हो और चाहे वो international foreign investor हो. लेकिन एक judicial climate को, एक judicial framework को, legislative framework को study कर investors आते हैं, both domestically and foreign investment as well looks at this. और increasingly हम देखते हैं, and this I would say again because I'm just talking about the background as yet, कि internationally भी अगर आप देखें तो there are international commercial courts as well. DIFC हो गया दुबई में, या जो अबू धाबी में है, कतर में है, पेरिस में है, सिंगापुर में है, लंदन में है. तो all of these international commercial courts, they are catering to international commercial disputes. Why? Because they don't want to necessarily submit their disputes to the jurisdiction of the courts of their trading partner. तो अगर एक international trade agreement है, एक international investment agreement है, so between two countries, we don't want to trust one other country's courts with our dispute exclusive jurisdiction हम उधर नहीं वेस्ट करना चाहते, तो हम इंटरनेशनल फोरम पे जाते हैं. एक इंटरनेशनल कमर्शियल कोर्ट्स भी इसीलिए इस्टेब्लिश हुए थे. तो ओवरऑल what is the investor always seeking? The investor is seeking fairness and transparency, free of corruption, free of interference. That is really the defining parameters of any court, whether it be a domestic dispute or an international dispute, whether it concerns business or private property rights. But that is what we are looking at. जो commercial courts का जो scope है जो इस वक्त हमने देखा है, to my mind, and again अभी I'm speaking broadly, कि commercial courts ordinance और जो procedure commercial courts को in this ordinance prescribe किया गया है, even though the civil procedure code is applicable, कौन सी खासियत है इस ordinance में which we would expect कि एक कमर्शियल कोर्ट प्रमोट करेगा और उसको फॉलो करेगा इन ऑर्डर टू मेक इट डिफरेंट फ्रॉम अदर एजुडिकेशन. टू माई माइंड इसमें एक जो खासियत इस ऑर्डिनेंस में दी गई है वो ये है कि वी आर मूविंग एजुडिकेशन क्लोजर टू आर्बिट्रेशन. व्हाई इज आर्बिट्रेशन अट्रैक्टिव फॉर business purposes, to businessmen, to traders, to investors? Because it is speedy, it is expeditious, it is more confidential, and the procedure is less strict. There are less adjournments given, the costs are heavy, costs are often awarded, etc. तो commercial courts ordinance भी मेरी अपनी इसकी examination के बाद I've come to the conclusion that all commercial court ordinances really, and I'm talking generally worldwide, they are focusing on the fact that they are trying to move adjudication whether it is under the commercial courts ordinance or generally in a commercial court, closer to what it would be in an arbitral tribunal. अब इसमें भी आप देख लें कि एक फाइलिंग का जो सिलसिला है वो ज़्यादा स्ट्रीमलाइन किया गया है. प्लेंट को एग्जामिन करना है, लीव टू डिफेंड का क्लॉज रखा गया है, इसको एक्सपेडाइट करने का, एडजर्नमेंट्स नहीं ग्रांट होनी, डिसीजन विद इन 6 months, एविडेंस किस तरह आना है, शॉर्टकट्स जितने प्रोवाइड किए गए हैं वो यही हैं कि सारा कुछ ये प्रोसीजर स्ट्रीमलाइन हो ताकि यू अराइव एट अ डिसीजन एट द एंड ऑफ द डे. कैन इट बी एट द कॉस्ट ऑफ fairness and transparency and a just and proper decision? Of course not. लेकिन it cannot also be at the cost of जो हमारा एक normal अब unfortunately perception भी है और reality भी है कि stay लेकर और उसके बाद adjournment सीख कर और businesses are suffering terribly, both domestically, international investor तो अभी they are not willing to enter into an agreement unless it has an arbitral clause and that the seat of arbitration is also abroad, preferably for a foreign investor. We want to change that climate. We want to see, I see this, कि in fact domestic commercial courts को establish करना मेरी नज़र में एक stepping stone है. What should our aim be is to have an international commercial court established in Pakistan. We should, the quality of our adjudication, the quality of our legislative and substantive and judicial framework should be such that we should aspire to be an international commercial court where international investors should seek out Pakistan as the forum where they would like their disputes heard and decided. तो मैं तो कहती हूँ कि अभी तो we are just taking baby steps in this direction and where we should be going. So this is just the background that I was wanting to talk about. जहाँ तक the actual scope of my lecture today is about ADR clauses and the scope of commercial courts. So I will be talking about basically what are the ADR clauses, what is the ADR system in Pakistan, and why we are, whether we are following it, we are not following it, and how the courts can help to expedite disputes because we already have ADR clauses. Generally, of course, commercial courts are confined to those disputes which are between firms, which are between domestic company, international companies, or between two domestic companies. But generally, to study ADR clauses, the arbitration clauses, what are the relevant acts? So, I don't know if this is up, but I will take you first to the background that we were talking about. Why ADR? So why ADR and why are we seeking commercial courts is also a hybrid form of ADR, in the sense that we are trying to streamline commercial disputes away from the mainstream of disputes that are existing in our courts at the moment, and we are trying to streamline it. We are trying to say that these disputes should be diverted to commercial courts. And why is that? Because of the caseload of traditional courts, because of the rising costs of litigation and time delays, and give the parties greater control over the selection of the individual or individuals who will decide their dispute, and justice delayed is justice denied, and to make it cost effective. These are the principles that underlie ADR. I would say these are the same principles with which you must approach adjudication in the commercial courts as well, that you are really trying to reduce the time, increase the speed, and decrease the costs of the litigant so that they arrive at a decision faster than they would in the traditional court system. ADR in Pakistan, why do we have arbitral clauses, mediation clauses, alternate dispute resolution clauses in investment and trade agreements? It is because in Pakistan, we have one judge for every 60,000 people, which does not make it possible to deliver timely justice. Over 1.87 million cases are still pending in the courts of Pakistan. According to the Law and Justice Commission of Pakistan, there are 38,359 cases pending in the Supreme Court and 293,947 cases pending in the 5 high courts. There is a clear need for ADR as it promises swift resolution to both civil and commercial disputes and to deburden our current system. Now, in Pakistan, I would say कि जो हमारा culture है, generally in the East and the Middle East, it is really, I feel that litigation and the adversarial procedures that we undergo in our courts are really based on a Western outlook, where two parties come together to spar over their dispute and they are shackled by the rules of procedure, by the code of civil procedure, and you have to undergo certain steps before you arrive at the final decision. Our culture is really based more on mediation, conciliation, पंचायत सिस्टम, जिरगा सिस्टम, समझौता कर लेना, सालस बिठा लेना, ये हमारे माशरे में है. It is very much a part of our culture and it is even codified in the laws that we have, which are unfortunately dysfunctional. But as a background, I feel that you should keep this in mind when you are adjudicating as well and as judges. So this is slide number 11, examples of the panchayat system and how it is codified in law. So there is the Local Government Act in Punjab, in KP, in Sindh, in Balochistan, in which either Maslahat Anjumans or Panchayat system is very much incorporated. So it is not something foreign to our culture. Arbitration, mediation, conciliation is very much part of our culture and it is incorporated in our laws, and there is nothing alien about it when it comes into our investment agreements as well. So we should keep this in mind as well. What is the governing legislation for ADR in Pakistan? Now, for ADR in Pakistan, there is of course Code of Civil Procedure. CPC में there is section 89A, which was to provide legal cover to the ADR method. Under this section, the court may, where it considers necessary, having regard to the facts and circumstances of the case, with the object of securing expeditious disposal of a case or in relation to a suit, adopt with the consent of the parties the ADR method, including mediation and conciliation. So section 89A is very much available that parties can be sent to mediation if there is some part of the dispute or the whole of the dispute that can be mediated, it should be sent to mediation. The Arbitration Act 1940, this is the ADR specific law. The Act provides for 3 classes of arbitration, that is arbitration without court intervention, arbitration where no suit is pending but through court, and arbitration when a case is pending in the court. Now, arbitration under the Arbitration Act 1940, I would urge you to look at the latest case law on this emanating from the Lahore High Court. Honorable Mr. Justice Jawad Hassan has passed a 2021 judgment on this issue about whether arbitration can just be made orally, and under the Arbitration Act 1940 it cannot be an oral request to take it to arbitration. The arbitration agreement has to be in writing. So I would urge, I think I will just give the title of the case as well, if you can take a look at this. So if there are 2 parties and they say कि नहीं ठीक है हम इसको arbitration में ले जाते हैं और कल को आकर वो award भी file कर देते हैं, तो this will not be a valid award because the arbitration agreement, unless it is in writing, cannot be pushed through the court simply orally. So it has to be in writing. Then there is the Small Claims and Minor Offences Ordinance 2002. This law provides that the court may resort to amicable settlement of dispute if it is possible at any stage. The Chief Justice shall, in consultation with the District Judge, the President Bar Association, prepare a list of persons to act as salis for amicable settlement. The parties may select the salis from other than the list. Section 16 to 18 of this ordinance provides procedure for settlement of disputes through a salis. The subject matters of ADR may be of civil or criminal as contained in the schedules annexed with this ordinance. So kindly keep this ordinance in mind. Arbitration Act of 2011. This is the International Investment Disputes Act, which has not been repealed as yet and is still very much in the field. The purpose of this act is to implement the International Convention on the Settlement of Investment Disputes between States, the ICSID Convention, with an aim to bringing transparency in the settlement of investment disputes. Of course, this has cost Pakistan many a times recently, as we have seen in the Rico-Dick case, etc. But until this ordinance is in the field and we are implementing the ICSID Convention, it remains very much a part of our ADR framework and the fabric of investment agreement climate in Pakistan, and it is imperative that you should familiarize yourself with this act. The Recognition and Enforcement Arbitration Agreements and Foreign Arbitral Awards Act 2011. The Foreign Arbitral Awards Act 2011 is relatively new, even though it may have been 10 years, but I find in practical consideration कि आज तक जब ये disputes और section 4, section 6 की applications under this act move होती हैं civil court में, तो एक confusion सी रहती है कि क्या ये civil court के ज़ुमरे में आता है इस तरह का dispute या नहीं आता है. So I think that has been finally settled. वो नहीं आता है. The section 4 application does apply to the High Court, and all these arbitral agreements अगर किसी foreign company के साथ हैं, so that should be referred to the High Court. The matter should be stayed, the proceedings should be stayed, and the matter has to be sent to foreign arbitration. So I think ये काफ़ी trainings में आपको बार बार दोहराया भी गया है, because I can see कि काफ़ी लोग जो हैं वो they are assuming this fact, and जो confusion पहले थी, conflicting judgments आ रही थी, कभी civil court की judgment आ जाती थी stay की, कभी high court की आ जाती थी, but finally this matter has been decided. अब exclusive jurisdiction High Court की है. Then there is different provinces have also made their own ADR and different territories. So ICT has its own ADR Act of 2017, Punjab ADR Act of 2019. Then the Sindh Amendment Bill to the CPC in 2018, where notwithstanding any other laws for the time being enforced, the court may use ADR methods. Then Order 9B, extremely important. This is the Punjab Amendment to the CPC in Order 9B. I'll come to that in more detail in my slide in which I've dedicated to Order 9B. This is Order 9B of the CPC, implemented by the amendment in Punjab in 2018. It governs the use of ADR, especially mediation referral by courts. So no longer is only Section 89A applicable, but Order 9B is also there, in which as you can see, we've just reproduced Order 9B over here, that if there is a dispute, it has to be referred to mediation. If that dispute is finally decided by the parties during mediation, the mediator can assist them in coming to a conciliation. Then that decision will be brought to court and stamp of court will be put on it and it will be final. If only a portion of the dispute is also resolved through mediation, that can also be brought, and that from the rest of the dispute the adjudication will be carried on. If no solution is reached through mediation, तो फिर भी the court will just carry on with the adjudication, but at least 30 days will be dedicated to mediation. Mediation or conciliation का ये फ़ायदा है कि it is a less formal procedure. There is a person there who is not necessarily a judge. He is just a dedicated mediator. He is assisting the parties in reaching a resolution so that they don't have to go through years of disputes in the courts. So I think ये सारी चीज़ें हमारे पास extensive legislative provisions हैं जिसके ऊपर rely करते हुए disputes can be referred to mediation, they can be referred to arbitration, they can be referred to conciliation. हर मामला कोर्ट को खुद रिजॉल्व करने का जो है इख्तियार ज़रूर है, लेकिन ज़रूरत भी नहीं है. जहाँ पर दिखाई दिया कि ये मैटर इस तरह का है, इस नेचर का है, या पार्टीज़ की विलिंगनेस नज़र आ रही है कि वो ये डिस्प्यूट खुद रिजॉल्व कर सकते हैं, तो the court can rely on a lot of these provisions that I have highlighted, and there are more, to send the matter to mediation and conciliation and assist the parties, assist the litigants in achieving their goals through a less formal procedure and a more friendly procedure, really. The Punjab Commercial Courts Ordinance. This is just more detail. For a copy, if you need a copy of this presentation, so please, you are willing to, the Academy has it, उनको मैंने forward कर दी है. इसमें extensively detail किया हुआ है each and every provision that you can look up and rely on in order to refer matters to mediation, conciliation and arbitration, and when you are bound to as judges to refer it, and when you are not bound and it is a discretionary power, वो सारी इसमें highlight की हुई हैं. So for paucity of time, I'm not going to stop at every slide, लेकिन this is available for you. A Punjab Commercial Courts Ordinance. The ordinance was promulgated on 13th April 2021, and it created the commercial courts to promote the expeditious disposal of claims arising out of commercial and contractual disputes between domestic and international corporations in Pakistan. The key provisions are that the commercial courts and tribunals will be created for the sole purpose of adjudicating on commercial and contractual disputes. Now, presumably, practically, ये इस तरह भी translate करेगा कि there will be specific judges, the learned judges sitting in this audience as well as others, who will be dedicated and assigned to these commercial cases. So these commercial cases will likely see consistency of judgments, which is an aim of the rule of law. कि एक consistency of judgment अगर आ जाती है, तो then this will be a very positive outcome of the commercial courts ordinance. जहाँ पर costs नहीं impose होती, we are often told and we often observe कि this is one of the major reasons कि हमारे यहाँ litigation की pendency इतनी ज़्यादा swell क्यों हो गई है और इतनी ज़्यादा pendency क्यों है, क्योंकि judges are unwilling to impose costs. Heavy costs, even nominal costs, are not imposed as routine. It is seen as very unusual, abnormal to be imposing costs, which should be imposed on the losing side, especially if frivolous claims are brought. For example, in the UK, such heavy costs are imposed that lawyers need insurance to cover their practice for giving wrong advice to take disputes to courts. Itne heavy costs to the tune of 20,000, 30,000 pounds are involved if you have taken a claim to court that is frivolous in nature and has wasted the time of the state and has wasted the time and money and resources of the other side. That insurance company might pay your insurance once. The second time your premium will be higher. The third time insurance companies don't insure those lawyers anymore. So it is a very, very high price to pay with the cost of your practice going if you are bringing frivolous claims to court. So that is the power in the hands of the judiciary as well, that you should be imposing costs on these frivolous claims in order to discourage litigation like this that is brought to courts and is wasting the time both of the state, of the litigant, discouraging business, and like people say that the legal system encourages people to take law into their own hands. जब आपको कोर्ट से relief नहीं मिलेगी तो people resort to taking the law into their own hands and finding ways to resolve it. फिर गलत तरीकों से FIRs lodge कर देना, harass करना, coercive tactics use करना. What is this? This is all a frustration with the judicial system itself. So then offshoots निकल आती हैं and people try and resolve it in any way that is available to them. So the point being कि again I will give the example of foreign jurisdictions. UK में the consistency of judgments is so established that very often, because the cost of lawyers is so high, sometimes they can just go for consultation and the lawyers, the law firms tell them that this is your dispute, 85% this is going to be the outcome. Go and represent yourself, you don't need a lawyer. Lawyer will cost you 5,000 pounds. You can just go and represent yourself because we know that this is going to be the outcome from this court. That is the extent and the scope of the consistency of judgments from those courts, that actually you can help the common citizen by saying that we know that this will be what the court decides. Discretion होनी चाहिए, लेकिन इतनी लार्ज नहीं होनी चाहिए कि आइडेंटिकल डिस्प्यूट्स आपके पास आ रहे हैं लेकिन किसी में कोई फैसला आ रहा है, किसी में कुछ फैसला आ रहा है. A rule of law is established when there is consistency of judgments, and coming back, bringing it back to the commercial courts ordinance, bringing it back that we have narrowed the disputes down to commercial courts only. उसका एक definitely ये incentive होगा कि जब consistency of judgments in courts से आएंगे एक जैसे disputes पर, तो it will create a lot of confidence in the investor, right? Now, the appointed commercial court secretariat will make the necessary arrangements for the training and continuous professional education of the judges. So I think it's very important कि जो courts assign हुई हैं, जो judges assign हुए हैं, if you are undergoing continuous training, if you are continuously up to date with the latest case law, with the latest international precedents, then you will also, the quality of adjudication will slowly improve over the years. And in fact, like I was saying, it is my dream to see an international commercial court established in Pakistan, inshallah, with the kind of training that we hope is going to be imparted to the commercial court judges. A physical and electronic record of all cases filed will be kept. I think this is, of course, a very much need of the hour. Okay, e-filing should be allowed, e-records should be kept. Entire countries like so many Eastern European countries, आज आप देख लें कि Latvia, Lithuania, Estonia, these are countries जहाँ पर पूरी governance is now e-governance. पूरी like everything is available digitally. Anything you need, the governance is all now digital governance. So why should we be moving in any direction other than, अब तो बिल्कुल there is no alternative वाला system आ गया है कि other than e-filing, other than digital records, we cannot turn back the clock and go in the other direction. This is the way of the future, and I think this is an excellent step to incorporate in the ordinance. और आप देख लें कि e-filing के साथ the discretion to swap papers, to change the record, etc., will be reduced enormously. The government, in consultation with the Chief Justice, shall frame rules. The government, in consultation with the Chief Justice, shall frame rules for the electronic filing of pleadings and written submissions. This is in Section 9, Subclause 1 of the ordinance. The court will dispose of all claims brought under this ordinance within 180 days, 6 months from the date of filing of the claim. Section 11, Subclause 1. The court shall not grant unnecessary adjournments, and in no case more than 2 adjournments shall be granted for a specific purpose. Section 11, Subclause 2. The court will have the power to determine and award costs against the parties. Section 12. So apart from Section 35A of the CPC, you have this power in your hand to impose special costs, and I hope that this will be exercised. All existing pending cases which satisfy the criteria for cases to be brought under this ordinance will stand transferred to the commercial court. So I think this is an excellent incorporation of this provision that even existing cases will be transferred to this court. So for example, when banking courts were established back in the day and all the banking cases were brought to the banking courts, immediately a consistency of judgment, a streamline ho gayi thi, adjudication, procedure, etc. And so many of the banks were relieved, loans were recalled, and ekdam se there was a definite improvement in the financial climate of the country. So I hope this will be achieved with the commercial courts as well. Actually, मुझे slides यहाँ से सही नहीं दिख रही, so I don't know if I'm exactly following what I am reading. But basically, to continue, the ordinance's encouragement and introduction of electronic filing is a major stride in speeding up the process of filing petitions and thereafter managing cases. However, the ordinance sets no time frame or deadline for when such a process should be implemented. So I think this would be probably need to be implemented by the judges कि judges को streamline करना होगा कि filing कब तक complete हो जानी चाहिए. इसमें कोई inordinate delay नहीं आ जाना चाहिए because ordinance में specifically ये incorporate नहीं किया गया. Discretion as to costs, wide discretion has been given to the judges to impose costs. Just for an example, where are we lacking, which I hope we can going forward commercial courts का scope किस तरह बढ़ सकता है, which we should aspire to. I will just give you a comparison. Between commercial courts in England and Wales, which is one of the most sought after jurisdictions to have your commercial disputes decided, and between the commercial courts as established in Pakistan, where are we lacking that I hope the legislature will at some point bridge this gap. वो ये है कि in England and Wales, commercial courts were introduced in 1895, so almost 120 years ago. They have had over 2 centuries to develop and perfect their commercial courts. The Commercial Courts Guide seeks to establish the intent and purpose of the commercial courts of England and Wales. The core intent behind the creation of their commercial courts is identical to that of the 2021 ordinance. To create a specialist judicial system for corporate entities and firms for the purposes of resolving commercial disputes. Dispute clauses in contracts specifying England and Wales as the relevant jurisdiction for disputes arising out of commercial contracts are now commonplace. The Commercial Court Guide of England and Wales has been revised to recognize the importance of arbitration in commercial disputes. Arbitration, the guide stipulates how arbitration claims are to be filed, what procedure should be adopted by commercial court when such claims are brought. The guide provides clarity and instills confidence in domestic and international corporations seeking to enforce arbitral awards throughout the specialist commercial courts of England and Wales. While the Ordinance of 2021 cannot be expected to achieve such heights at this premature stage, there is no reason why it should not aim to do so. Given the popularity of arbitration amongst international corporations as an option for dispute resolution, the ordinance should be revised to bring the arbitral awards under the jurisdiction of the specialist commercial courts that it seeks to create. So my point being कि जितने भी enforcement of arbitral awards होते हैं, they should also be confined to the commercial courts. Commercial courts को ही इन्हीं जो assigned judges हैं to the commercial courts, उन्हीं को training देनी चाहिए in the enforcement of arbitral awards to keep getting trained for what the latest case law is on this, how narrow the scope is in which an arbitral award can be challenged, what are the parameters to be kept in mind when you are enforcing an arbitral award, and इसकी enforcement के लिए why is it important to have a speedy enforcement? Otherwise, what is the point of arbitration? आज को आपका कोई mostly the arbitrators in big disputes that undergo arbitration are retired judges of the Supreme Court, but their awards are sometimes set aside by the civil judges. So this happens because the judges are not trained, that the judges are looking very narrowly, the civil judges are looking narrowly at the CPC. So if a certain, like let's say there is a procedural lapse during the arbitration, they will say, oh, null and void award, right? But if you are trained in looking at to the enforcement of arbitral awards and how it should be done, then there is every chance that arbitral awards enforcement will become smoother, more streamlined, and more easily implementable. So I think this is one place where the Commercial Courts Ordinance should aspire for amendment later on as we go along. So I think my time has also come to an end, and I can see that the next speaker is here, but I'd be happy to take questions if there are any. No, I think that this, where there is a pecuniary clause that is also there. Let's have a look at section 17. Any suit or appeal that is relating to a commercial dispute filed or pending in a commercial court or tribunal, as the case may be, shall, after leave to defend or appeal is accepted, be referred to ADR by the commercial court or tribunal in accordance with provisions of Order 9B of the Code. Where the word shall is used, it is mandatory. So where the word shall is used, and there is a 2016, I think, Supreme Court judgment in this and many others, that it is mandatory to refer it to, under Order 9B, the provisions of Order 9B, to ADR. If it is not resolved, it comes back to the commercial court.